Today, we're going to be talking about some of the pitfalls that I see with do-it-yourself or DIY trust and estate plans, as well as document generation providers. As always, we've got a lot more content coming your way, so if you could like and subscribe, we'd much appreciate it, and we're happy to share plenty of more interesting topics with you along the way, but let's go ahead and get started. So many people would be surprised to hear that really only 11% of people in America have trusts, and about 31% of people are estimated to even have wills. Now, the difference between a trust and a will generally is that a will has to still go through probate. When we're doing an estate plan, we're trying to accomplish three different goals. The first is to avoid probate. Now, probate is the lengthy court oversight that requires valuation of assets. It requires supervision of distribution and valuation. It can be costly, it can be timely. So we're hoping to be able to do an estate plan that allows somebody's assets to be transferred or distributed to their heirs, their beneficiaries, outside of having to do that. The second goal is to maximize the value of the estate. We want to make sure that we take advantage of all tax planning strategies that are available to us. And then the third is we want to avoid confusion and conflict. We want to make sure that the estate plan is clear. We want to make sure that the beneficiaries, whether it be your heirs, whether it be relatives, whether it be your friends, they're not fighting over who gets control or who gets what. So those are the main three goals that we're looking for when we are creating an estate plan. One of the most common misconceptions I see when people begin discussing estate plans with me for the first time is they think estate planning is just filling out forms. Just because you go to a provider and generate a document doesn't necessarily mean that your estate planning document, whether it be a will, whether it be a trust, whether it be a power of attorney or healthcare directive form, doesn't mean it's invalid. But what it means is you're just entering that information. You're not necessarily paying too much mind to what are the terms saying, whether the clauses in that documents conflict with one another or whether they conflict with inside the document itself. Another common misconception is that DIY planning saves money. Now, if your estate is simple enough, maybe it will, but there are still plenty of pitfalls here you need to watch out for. One is, are you executing these documents in a valid way? Are you signing them properly? Are you dating them properly? Are you getting them notarized? These are the kind of things that an estate planning attorney looks for each time we get a new set of estate planning documents. Now, a third common misconception that we see is that estate planning is one size fits all. Sometimes that is a common approach that we see in these document generation providers, that they'll give you a very generic document and it's going to fit exactly what you need. Everybody's family is different, everybody's interests can be different, and everybody's goals can be different. So what a seasoned estate planning will do in creating an estate plan for a client is sit down with them, talk about what their biggest concerns are. What kind of assets do they have? What do their beneficiaries look like? Does this beneficiary have special needs? Some sort of illness that requires somebody to manage the money for them? Or does this beneficiary need somebody to look out for the money until they become a certain age? We want to assess, okay, are we looking at a blended family? Is this a joint trust where each spouse in the trust has children from a different marriage? How are these distributions going to be created? Are there prenuptial agreements involved? Then we have issues, especially in California, if what is separate and what's community property. Now, when it comes to DIY planning and document generation, the execution might be pretty quick. You might draft up the documents yourself or get them online and then sign them, and boom, you think, okay, I've got a valid document. Now, it could be valid, but there is maintenance that needs to be done. There's other actions that need to be considered with respect to, okay, you might have a trust, but have you funded it properly? Meaning, have you properly transferred your assets to your trust? So oftentimes, what might happen is somebody either creates a trust or a will on their own, or they go through some sort of a provider to have this trust created really quickly, but they fail to transfer their assets or retitle them in the name of the trust. What that leads to later is actually more steps to be addressed that were missed in the past, whether that be going to court to have property that was left out of a trust moved into a trust, or taking additional remedial steps necessary to properly fund the trust that could have been avoided if you had properly funded the trust yourself in the first place. Another common oversight that I see is, okay, I've got my will, I've got my trust, I've got my powers of attorney and healthcare directives, I'm set. With estate planning, it's never really just set it for forget it. It's an evolving document, it's an evolving plan. A seasoned attorney will let the client know if there are certain events that occur that their estate plan might warrant another review, maybe an amendment. That could be if you sell a piece of property, if you get married, if somebody that you named as your successor trustee moves away. At that point, you should contact an estate planning attorney to make some amendments to your trust. So it's an ongoing process rather than just setting it and forgetting it and thinking that it's going to take you all the way to the end. The last and I think most important thing is we want to make sure that our estate plan reduces and minimizes any conflict and confusion. Oftentimes people's estates are much more complex and require more attention. So let's say, for example, somebody has a business that they're running and they want to fund that into their trust. Well, a generic document might not address the governance of that business. It might not address what happens to that business if the settlor were to pass away. Is that business liquidated? Is it being continued to run? Is it held for somebody's benefit? What does the client intend to do with this asset? Just another thing to think about in terms of reducing that conflict, reducing ambiguity, and having a full plan that accounts for those contingencies. As an estate planning attorney, it's always important that we tailor that estate plan to the client's needs, to the client's concerns, and continue to revisit those terms as time goes on so that if changes are needed, they can be addressed in a timely manner. So estate planning is more than just forms. It's about foresight. It's about planning. It's about providing for those that you care about. If this video has helped you, please drop a comment in our comment section. We hope that you throw us a like and a subscribe, and stay tuned. We've got plenty more videos coming. As always, if you have questions, feel free to visit our website. Stay safe, stay protected, and you can do so by staying prepared.